This is Barry Zalma on insurance. Today I'd like to speak about grounds for declaring a policy void. A life insurance policy, procured with the intent to benefit persons without an insurable interest in the life of the insured, does violate the public policy of New Jersey, and such a policy is therefore void at the outset. Consider Sun Life Assurance versus Wells Fargo, a 2019 decision of the New Jersey Supreme Court. When a policy is declared void by the insurer, the most common ground is that the insured has breached a condition of the policy which effectively forfeits the policy. Forfeiture is defined in Webster's Third International Unabridged Dictionary as loss of some right, privilege, in consequence of a breach of a condition or other act. Generally, if the insurer accepts unearned premiums from the insured at the time of forfeiture or voidance, with the knowledge of facts indicating a forfeiture, the insurer waives its right to defend on that ground. If it doesn't do so, there is no waiver. In that regard, the standard fire policy provides, as required by statute in almost every state, quote, concealment fraud. This entire policy shall be void if, whether before or after a loss, the insured has willfully concealed or misrepresented any material fact or circumstance concerning this insurance, or the subject thereof, or the interest of the insured therein, or in case of any fraud or false swearing by the insured relating thereto. Close quote. Whenever an adjuster determines, as part of the thorough investigation required by law, that a policy should be declared void based upon policy language similar to the language in the standard fire policy, he or she should coordinate with the underwriting department so that the underwriters are aware of the action and do not inadvertently waive a viable defense. The adjuster should be certain that a copy of the letter declaring that a policy is void is placed in the underwriting file as well as the claims file, and the insurance agent or broker should be advised that the policy has been declared void, and they should not try to reinstate the policy. In South Carolina Farm Bureau versus Kelly, a 2001 decision of the South Carolina Court of Appeal, it held that, quote, we find the case of Tyler versus Fireman's Fund, a 1992 Montana Supreme Court case, particularly instructive. In Tyler, an insurance company brought an action to recover on a claim it had already paid the insureds after learning that a fire was intentionally set by one of them. The court held that an insurer could recover for claims paid due to fraud even if one insured was not aware of any fraud. As in that case, the language of the insurance policy specifically stated it would be void if the insured willfully concealed or misrepresented any material fact or circumstance concerning the insurance policy. The court stated that a party is entitled to recover money which it paid by mistake of fact or law, and which the receiver ought not to retain in equity and good conscience. The South Carolina court made it clear that not only is a policy void when an insured commits an intentional act like arson for profit, but the insurer who learns of such a fraud after making payment may sue the insured to recover the funds paid plus expenses. If there was fairness in the world, they would also be entitled to collect tort damages from the insured who has breached the covenant of good faith and fair dealing. But unfortunately, the law of the United States is only an insurer can be held for tort damages if it breaches the covenant of good faith and fair dealing. Upholding an insurer's right to void the policy from its inception, a court held that the insurer's contractual commitment to avoid material misrepresentations extended to misrepresentations that strike at the heart of the insurer's ability to acquire the information necessary to determine its obligations and protect itself from false claims. The insurer did not make a mere oversight or honest mistake. Rather, he made a knowing misrepresentation of a material fact. Notwithstanding that, even though the misrepresentation was not made at the inception of the insurance agreement, the court held that the insurer was justified in declaring the policy void. The insurer in such a situation must prove there was a knowing misrepresentation of fact with the intent of the insureds to have the insurer rely upon it to its detriment from the outset. It is axiomatic that in order to state a claim for fraudulent inducement, there must be a knowing misrepresentation of material present fact which is intended to deceive another party and induce that party to act on it, resulting in injury. Therefore, the proof required to prove voidance of an insurance policy is the same as required for common law fraud: a misrepresentation or concealment of a material fact made with the intent to deceive the insurer, that in fact does deceive the insurer into entering into the contract of insurance or in dealing with a claim presented, and that the insurer was damaged as a result of the material misrepresentation or concealment of material fact. Now, voidance as a breach of contract provision is different from the equitable remedy of rescission. When the United States was conceived in 1776, the founders were concerned with protecting their rights under British common law. They adopted it as the law of the new United States of America, modified only by the limitations placed on the central government in the U.S. Constitution that was approved later in 1789. The viability and ability to enforce contracts was recognized as essential to commerce. Courts of law were charged with enforcing legitimate contracts. Courts of equity were charged with protecting contracting parties from mistake, fraud, misrepresentation, and concealment, since enforcing a contract based on mistake, fraud, misrepresentation, or concealment would simply not be fair. The common law developed rules that courts could follow to refuse to enforce the terms of a contract that was entered into because of mutual mistake of material fact, a unilateral mistake of a material fact, the breach of a warranty, a presumptively material promise to do or not do something, a material concealment, or a material misrepresentation. The remedy, called rescission, created a method to apply fairness to the insurance contract and allow an insurer to void a contract, and allowed courts to refuse to enforce such a contract entered into by misrepresentation or concealment. Therefore, the remedy of voidance is a decision made by a court of law based upon the fraudulent acts of the insured, while the rescission of an insurance policy is based upon fairness and is ruled by courts of equity, who require, in the case of rescission, that the insurer return all premium to the insured whose policy has been declared void from its inception, and that the insured return to the insurer the policy itself, so that there is the remedy that the policy, although entered into because of fraud, misrepresentation, concealment, or mistake, was entered into in error, and therefore has to be treated as if it never existed. This video was adapted from my book, Zalma on Insurance Claims, Part 103, 3rd edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be interesting or useful to your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel, my Rumble channel, my blog, and my Substack publications so that you can learn of future videos and future blog postings. Thank you for your attention.